Hello everyone, and welcome to Uncivil Law. For today's case, we have a case on a 1983 cause of action from the First Court of Appeals for the First Circuit. This is Ronaldo Panetti versus James Hanich. In this case, there was a person who was working at a drug testing lab for the government. Their job was to test the drugs to see whether or not they were in fact drugs for many criminal cases. However, part of their job duties got to them. They decided to start sampling the products and did so to some sort of fame and acclaim in the amount that they were using it. So we're going to read a little bit about the story when they were first busted, and then we're going to read a little bit about the civil suit that has just been decided as part of this. So let's get started with this. So first we begin from this story from April of 2018, in which it is decided that 7,500 cases were going to be dismissed due to an ex-state's chemist misconduct. Let's read a little bit about it. A Massachusetts Supreme Judicial Court justice on Thursday ordered a dismissal of more than 11,000 convictions in more than 7,500 cases. These cases are connected with former state drug lab chemist Sonja Farak, who pleaded guilty in 2014 to charges of stealing and using drugs from the Amherst lab where she worked in more than a decade. But that, my friends, does not really tell the full story of what happened. Let's read the civil lawsuit to learn more. From the 1960s until July 2012, the Massachusetts Department of Public Health operated the Amherst Drug Lab on the campus of the University of Massachusetts. Massachusetts State Police assumed operation of the lab from July 2012 until the lab closed on 2013. The lab analyzed substances submitted by law enforcement agencies in that state to determine whether samples contained controlled substances. Chemists at the lab tested thousands of samples every year. The exact manner of how they tested it, however, is an item of issue. Sonja Farak was hired by the Department of Health in July 2003 as a drug lab chemist. In 2004, she was transferred to the Amherst lab where Hanich worked. That same year, she started stealing and abusing on a near-daily basis the methamphetamine oil that the lab kept in an opaque bottle as standard. So she's using the standard that has been applied to actually test the drugs against. She's using that as her supply. So I guess she knows that it's the best stuff money can buy because it is the legal standard used for testing. So only the best will do. Soon after Hanich was promoted, Farak overheard him talking about an audit that was planned to perform of the lab supplies. She realized that after almost 4 years of stealing, the lab supply of methamphetamine oil was substantially depleted. How much oil do you have on stock? I wonder, at any given time. That's a good question. She'd been using it on a daily basis, and 4 years later, there was still some left? Wow. Farak added water to the oil to cover up her drug use. Bad plan. Oil and water do not mix. But I'm not a chemist or anything. During the audit, Hanich, the supervisor, noticed the sample's strange appearance, but surmised that the drug was just degrading. No further inquiry was instituted. That's just great. After this, Farak started stealing and using the lab's other drug standards, including amphetamine, phentermine, ketamine, cocaine, ecstasy, marijuana, and LSD. She's getting bolder. After that work, she's like, why not just use all the samples? I'm now using all the drugs. The government approved drugs. The ones that are used as a sample. Fantastic. By at least April of 2009, Farak had expanded from stealing standards to a new source of drugs. Oh, good. Well, new source. That's good news. At least she's not stealing standards anymore. I mean, what could possibly be worse? She started taking and using portions of the drugs from some of the samples that had submitted by law enforcement officers for testing. Oh, that may be worse, yes. She's now using for her supply the stuff that was confiscated off the suspects that was sent for testing. So that's just great news. She's using miscellaneous street supply that may or may not contain the drugs. Great. At least twice in 2010, she expressed concern to her therapist that her coworkers might suspect her drug use. This is my shocked face. By the fall of 2011, she was heavily addicted to crack cocaine, smoking the drug more than 10 times a day, including at the lab. She's smoking crack cocaine at the drug testing lab. Outstanding. It was during this period, the fall of 2011, that samples from substances Panett allegedly sold to an undercover police officer were signed to Farak for testing. Panett is the guy who is suing, by the way, for the 1983 violation. So he's arguing that his case was corrupt because of this woman. So stuff we're taking off him and submitted for testing. Let's read on. It is not specifically alleged that Farak took any of the Panett drug samples for her own use, but it appears she did use other police-submitted drugs during this period in which she was testing Panett's samples. On December the 22nd, 2011, she wrote on a diary card she was keeping as part of her treatment for her drug addiction, tried to resist using at work, but ended up failing. Panett's 1983 complaint alleges that on January the 9th, 2012, the day of the last test of the Panett samples, Farak smoked crack cocaine in the morning, stole LSD from a police-submitted sample unrelated to the criminal case, and then spent the remainder of her day hallucinating. This is a proof that sometimes government workers have some issues, so yeah. How hard is it to fire someone in Massachusetts? But does it get any worse? Several times that year, Farak manufactured crack cocaine from powdered cocaine at the lab for her personal use. Okay, guys, she's now taking crack cocaine that has been taken off drug users, submitted by the police, and she's now converting the cocaine into crack cocaine using the lab facilities of the drug testing lab in order to convert the cocaine into crack cocaine that she can then smoke at the lab. This woman is special. Wow. At unknown times through her employment at the lab, Farak's drug abuse caused her to hallucinate, to experience what she described as ridiculously intense cravings, to feel like her mind was racing, and to take frequent breaks from work to use drugs. I wonder if the standard policies on how many smoke breaks you get at work apply when the smoke at question is crack cocaine. These are the questions that remain unanswered. A year after the Panett test, the guy who is suing here, in early January 2013, Farak made crack cocaine at the lab. Hanach, her boss, found a leftover beaker with white residue in it. He confronted Farak. She denied knowing anything about it, and he, in the face of the denial, mistakenly decided another coworker must have brought her daughter to the lab and did a science experiment. Even if you thought that's what really happened, isn't that kind of a problem? Just bring your daughter. I don't know if bring your daughter to work day is necessarily the best idea when it's a drug testing lab and what you're going to do is use the equipment for some sort of lab experiment. Seems questionable. Tessa, to your question. When did the crack smell? One would presume, but it is a drug testing lab, so I'm going to go ahead and assume that she was smoking where there was some sort of fume hoods or something in order to escape the smoke. So I assume she had that covered, so that's good times. Farak pleaded guilty in 2014 to multiple counts of evidence tampering, larceny of controlled substances, and unlawful possession. On December the 13th, 2013, the Panett, the guy that's suing here, was convicted of a single count of distributing a Class A substance. He was sentenced to 5 to 7 years in prison. When the fuller scope of Farak's drug use came to light, Panett moved for a new trial. Panett's conviction was vacated, his indictment was dismissed with prejudice, and was released from prison the next day. So we see what happened here. Panett was sent to jail for drug use. But of course, she was tampering with the supply and diluting the supply. So we no longer have confidence in the drug use results. And he was sentenced to 5 to 7 years in jail and actually served some of that time in jail. So his rights were taken away from him by being put in jail, perhaps completely unjustly. So he has been set free, but he was put in jail, in part because the government put him there, in part because this lab run and relied on by the government was being so hideously misused. So he's bringing a 1983 complaint that his rights were taken away because of the drug use and mismanagement of this facility. So let's read on to see if he has a claim. Panett brought this lawsuit under Section 1983 for violation of rights. The magistrate judge denied Hanach's motion to dismiss the 1983 claim on the basis the law was clearly established at the time that state lab chemists and their supervisors have a duty under Brady versus Maryland to disclose exculpatory evidence. So here the trial judge initially said, I'm not going to dismiss this complaint because the lab was well aware of its duty to present any evidence that would mitigate against conviction, and they didn't do that, so that would be a 1983 violation according to the district court. Let's read on. The magistrate judge found the same behavior, characterized as showing a disregard for repeated red flags, was enough to state a claim for intentional infliction of emotional distress under state law because it was evidence of deliberate disregard of substantial possibility that the actions would produce severe emotional distress. So here the magistrate judge is finding, look, the lab, you guys had all these kind of red flags. This is going on forever and you ignored it. And you ignored it in knowledge of that, so that makes it intentional. And so you intentionally absorb the consequences of that. One of the things that might happen is someone might be punished unjustly. And so you can be liable for infliction of emotional distress. So that's what the trial court found. Let's read on. The qualified immunity inquiry proceeds with a now familiar two-part test. Whether the facts alleged or shown by plaintiff make out a violation of a constitutional right, and if so, whether the right was clearly established at the time of defendant's alleged violation. The test is refined further in supervisory liability cases. The clearly established inquiry as to supervisors, that's who's being sued here, the lab, the supervision authority, is bifurcated. That standard is only reached when the subordinate's actions violate a clearly established right and it was clearly established the supervisor would be liable for the constitutional violations perpetrated by subordinates in that context. So under standard 1983 analysis, there is not what's called vicarious liability. Vicarious liability is A did B, B did C, therefore A did C, right? So it's holding each step of the way. And a 1983 violation normally doesn't have vicarious liability. So it normally isn't the case that because subordinate did it, therefore supervisor is guilty. Now in normal lawsuit land, in normal lawsuits, that would normally apply. The employer would be liable under what's called respondeat superior liability. Your employee did something in the scope of their official employment. You're the supervisor and you have responsibility for that. So if this was private, then it would be different, but it's government. And so under 1983, respondeat superior vicarious liability does not apply. And so you have to find special liability, not only to the subordinate, but also to the supervisor as well in order to do that. Just because the subordinate is liable, respondeat superior does not apply. You have to find separate liability as a matter of law for the supervisor as well. Let's read on. Our inquiry centers on whether the supervisor, under the specific facts alleged in this case, should have understood his conduct jeopardized Hanach's constitutional rights. We hold the supervisor, Hanach, is entitled to qualified immunity because, under the circumstances alleged, an objectively reasonable lab supervisor would not have discerned that his acts and omissions threatened to violate the constitutional rights of criminal defendants whose suspected narcotics were being tested at the lab. So, although it might have been clearly established in some respects, not in this respect, and therefore no liability. As of 2013, several First Circuit cases have said liability for superiors is only triggered under 1983 if a plaintiff can establish that his or her constitutional injury resulted from direct acts or omissions of that official, or from indirect conduct that amounts to condemnation or tacit authorization. So under the law in the First Circuit, you need to show direct acts from the supervisor or actual or tacit authorization to do it. So you need to show that supervisor is effectively directly contributing to show the supervisor is liable. And that's not being shown here. That's the difference. The supervisor's failure to investigate further in response to the incidences referred to above, singularly or collectively, did not rise to the level of deliberate indifference. These particular incidents, far from being instances of known unconstitutional activity, were all plausibly subject to explanations which would not reasonably trigger further investigations. So on the record before us, according to this court, we're aware of only 3 specific instances. Now, some of those instances are kind of severe. During an audit, we found that the source substance was not as it should be. We found white residue in a beaker and so forth and so on. but it's not on its face enough because each is submissible to some sort of plausible explanation, so it's not deliberate blindness. So it's not enough to show willful action by the supervisor, and that's the difference here. Panat pleads many facts about the lab's lack of security protocol and the supervisor's failure to oversee meaningfully the chemists under the supervision. But even if the supervisor were negligent in his supervisor duties, that does not suffice. Negligence is not enough. These general allegations do not show Hanach, the supervisor, was on notice that his supervisory failings amounted to a violation of the constitutional rights of others. And that's the relevant question, whether he was on notice that what he was doing was going to violate other constitutional rights. Because under 1983 analysis, you need to have it clearly established at the time. And it wasn't clearly established at the time that, these incidents and saying, oh, it must be part of some mistake was enough. So I understand the court. What they're saying makes sense on its facts. Although it's somewhat hard to believe these were the only 3 incidents for a person that was this brazen, this long, but it's the only facts that were shown in this case. So, what they were doing to hide the evidence, who knows? But yeah. In sum, Panat has not shown that, under the facts alleged, Hanach, the supervisor, clearly acted with deliberate indifference to Farak's alleged Brady violations. Those would be violations for failing to turn over exculpatory material, or otherwise should have understood that his acts or omissions jeopardized Panat's constitutional rights. Accordingly, Hanach is entitled to qualified immunity, and we reverse the district court's denial of the motion to dismiss. So that is the end of the case of Ronaldo Panat versus James Hanach. In this case, we learned that someone who had been sent to jail for 5 to 7 years for drug violations was set free because the person who tested their drugs was consuming the supply and tainting the results. And the person who had been sent to jail, obviously very upset about this, decided to sue the lab and decided to sue the supervisor for failing to properly supervise, and in doing so, deprive them of constitutional rights under 1983 violation. However, as we learned, vicarious liability, respondeat superior liability, is not something that typically applies in the case of state action, and so you need to show direct action by the supervisor, which was not shown under these facts. So as a result, the decision below is reversed. There is not a 1983 violation. James Hanach, the supervisor, is not liable, and that is the end of this case.